Diddy's legal team won't call witnesses as trial nears closing. Former prosecutor backs the strategy. As the federal trial of Sean Diddy Combs barrels toward its conclusion, the music mogul's defense team has announced a bold and highly calculated move. They will not call any witnesses, including Diddy himself, to testify in his defense. With closing arguments expected to begin on Thursday, June 26, and jury deliberations possibly starting as soon as Friday, legal experts say this strategy may be the smartest play the defense has made so far. Combs has pleaded not guilty to a wide-ranging set of federal charges, including sex trafficking, racketeering, and transportation for prostitution, all under the framework of a federal racketeering conspiracy, RICO case. Over the past several weeks, the prosecution has presented a mountain of evidence, including testimony from 34 witnesses, digital messages, surveillance footage, and financial records. The charges paint a dark and complex portrait of an alleged criminal enterprise run from within Combs' music empire, accusations the music mogul has vigorously denied. Yet, as the government prepares to rest its case, Combs' legal team has chosen to rest their own case without presenting any witnesses or additional evidence. That means Diddy will not take the stand, and the defense won't introduce any counter-testimony or expert analysis to directly rebut the prosecution's narrative. But according to legal insiders, this approach may be more than just minimalistic. It may be tactically brilliant. It would be a huge risk for Diddy to testify. Former federal prosecutor Mark D. Chutkout told People that the decision not to put Diddy on the stand is grounded in solid legal strategy. It would be a huge risk for Diddy to testify, said Chutkow. The prosecution has already introduced extensive evidence of alleged misconduct. Taking the stand would open the door for even more damaging material to be introduced during cross-examination. Strategically, staying silent protects him from further exposure. Allowing Diddy to testify would expose him to potentially damning questions from prosecutors, who could use the opportunity to corner him with statements, texts, or behaviors previously brought up during the trial, or introduce new elements not yet in play. Testifying could also open up material from the over 60 pending civil lawsuits Diddy currently faces, as anything he says under oath could potentially be used in those cases. Less is more. A powerful courtroom strategy. Rather than building a defense with its own witnesses or experts, Diddy's team has opted to rely on their cross-examination of the prosecution's 34 witnesses, aiming to cast doubt on their credibility and the integrity of the evidence itself. According to Chutkow, this method allows the defense to argue in closing that the government has not met its burden of proof, which is solely on the prosecution in any criminal case. Choosing not to prolong the trial can work in their favor, Chutkow continued. They can remind the jury that Diddy is presumed innocent, and that the burden of proof lies entirely with the prosecution, a burden the defense will argue has not been met. The less is more tactic can often be effective in cases involving high-profile defendants. It reduces the chances of a misstep or an emotional witness that could backfire. And by declining to present a defense case, the team avoids the risk of a weak or inconsistent narrative being introduced, which could damage their client's standing with the jury. If the defense were to present a weak case, it could hurt Diddy more than help him, Chutkow added. Less is more can be a powerful defense in criminal trials. Using stipulated evidence, such as agreed-upon messages between Diddy and alleged victims, keeps the defense in control without opening the door to rebuttal witnesses from the prosecution. Other experts agree. It's about limiting risk. Former federal prosecutor Neema Rahmani also weighed in earlier in the case, emphasizing that Diddy's potential civil exposure makes testifying a dangerous proposition. With dozens of women coming forward in civil court, anything Diddy says under oath could haunt him long after this trial ends. This isn't just about winning this case, it's about not jeopardizing future ones, Rahmani previously said. When a defendant has that many civil lawsuits hanging over him, every word he says can become ammunition. By choosing silence, Combs' attorneys are making a chess move, not a retreat. They are betting that the jury, which has now sat through weeks of graphic and emotional testimony, might be experiencing a kind of evidence fatigue. With no fresh, potentially inflammatory material introduced by the defense, the case now turns to closing arguments, where Diddy's team will make their final appeal to jurors that there is not enough credible, irrefutable proof to convict. A waiting game begins. The outcome of this landmark trial could have significant implications, not just for Sean Combs' career and legacy, but for how RICO laws are applied in entertainment and celebrity culture. As the jury prepares to deliberate, all eyes will be on the federal courthouse and what may be one of the most consequential verdicts in the music industry's legal history. Sean Diddy Combs continues to maintain his innocence and denies all criminal charges.